Hello everyone, welcome back to our channel. This video is going to be about CA Final, Self-Paced Online Modules, Set A, Corporate and Economic Laws. That too in Company Law we are going to see about Chapter number 6, Prevention of Oppression and Mismanagement. This is the main agenda for this video. Now, before moving into the chapter, I would like to tell you one thing. Here, this notes which I am using here, it will be available in our website. The highlighted PDF of the study material along with the charts that I have included for multiple places. So, along with that, the entire notes PDF will be available in our website. Now, I will show you how to access the resources from the website. Now here in the browser you can type Mission CA Virtuals and then you can see the first page which is opened and here you can click on it. Now here if you see, you will see this tab CA Final SPOM free resources. When you go into that, you will be able to find all the SPOM resources. Set A, Set B, Set C, Set D, everything will be there. Instead of scrolling through Telegram channel, word messages and all, you can just come here and then find these resources. Just you have to log in into the website, then you can access the resources for free. So all the YouTube channel links, YouTube videos links, and then the resources PDF, everything will be uploaded here. Inside the Set A folder, it will be available. So you can easily come into this website, log in with your mobile number and then view the PDF resources. So now we can start the chapter. Now we can start the chapter Prevention of Oppression and Mismanagement. So here first we are going to see the case law. One case law which is called as Fox versus Harbottle rule. So here what the court is saying, they are saying that a company is a legal entity separate from the shareholders. Shareholders are different, company is different. If the company's assets were misappropriated and improperly they mortgaged the assets, in that case it is a wrongdoing done to the company. The company is the one affected in this particular matter. So only the company can file the case, not the shareholders. If something is happening within the internal management of the company, normally court will not interfere in that. But we are having four exceptions for that. First one, ultra virus or illegal act. Then transaction requiring special majority. Then personal rights, fraud on the minority. So if these are happening, even if it is inside the internal management of the company, the court can interfere. Now, in this chapter, we are going to see about the fraud on the minority. We are having the shareholders in a company. We are having a small group of shareholders. They are called as the minority shareholders. Majority shareholder will be someone who is holding the majority shares. The people who are remaining shareholders in the company, they will be called as the minority shareholders. If you are not giving them any rights, or you are oppressing them, or you are making any fraud on them, then also you can file an application under this particular chapter. So that is the meaning of prevention of oppression and mismanagement, where there is a fraud on the minority. We can see the meaning of oppression and then the mismanagement. Now, here when you see the meaning of oppression, they have given that you should be affected in the capacity of a shareholder. As a shareholder, you are affected. Because of that, you are filing an application under this chapter. That is allowed. But you are a director. Your director rights, they are not giving it. For that, you cannot file a petition under this chapter. As a director, if you are given harsh or unfair treatment, you are experiencing unfair treatment in the capacity of a director, then it is outside the purview of this chapter. Then there should be continuous acts, not a single act. Continuous act should be there up to the date of petition. Then the single act, you should not consider it separately. You should consider it together. You should be a part of the continuous suffering. Till this date of petition, they were suffering the act which were done by the oppressors. Then burdensome, harsh, and wrongful act should be involved, and it should have one lack of fair dealing. It should not be fair, like unfair treatment should be there. Only then you can call it as an oppression. Then the management of the company, if they had done any fraud, misfeasance, or misconduct when towards the members, only then it can be considered as oppression. Normal domestic dispute, member told one thing, director did not agree to it, that and all will not come under oppression. Fraud, misfeasance, misconduct, that and all should be there in the part of the director or the management of the company. Now, when you are experiencing oppression or mismanagement, you can file an application to the tribunal. What is the application? You can apply to the tribunal and get a lot of orders from the tribunal, like to set aside the contract, to remove the director, to what we can say, we can do a lot of things. Tribunal has a wide range of powers that we are going to see separately. Here when you see everything, reduction of the capital, restriction on transfer of share, everything is there with the powers of the tribunal. To regulate the company, the tribunal can do anything. Now, here, the right of the member to apply to the tribunal. When they can apply to the tribunal, the member shareholder, he thinks that the affairs of the company business, or the company state of affairs is connected in such a manner which is prejudicial to the public interest, which is harmful to the public interest. Prejudicial means harmful. It is harmful to the public interest, or it is harmful to the company's interest. It is not good either to the public or to the company itself, or it is oppressive to any member. You are facing these problems. It is oppressive to any particular member. Then the member can apply to the tribunal. Then they are bringing a material change in the management or control of the company. They are bringing a big change in the management of or control of the company. What change they are bringing? Alteration in the board or manager, change in the ownership or membership, any other change. Like this, are bringing any big changes, material changes, which are what we can say, in the opinion of the member, it is not good for the interest of the members or the company. It is not good for the interest. It is harmful in the opinion of the member. These changes, then the member can apply to the tribunal. But this change should not be in the interest of the debenture holder. You are making a change in favor of the debenture holder. In favor of the debenture holder. For example, debenture holder is there. You are appointing a representative of the debenture holder in the board of directors. This and all will not come under this chapter. For this and all, you cannot file an application under this chapter. So, alteration in the board of directors or manager, change in the ownership, change in the membership, or any other change. Now, here, not only the member, even if the central government has the opinion that the company is not conducted properly, then the central government can, on its own, it can take the case and it can apply to the tribunal. Either the member or the central government can apply here. Central government will apply to the tribunal, and such application will be made before the principal bench of the tribunal. When central government is starting the case, why they will start the case? That reasons they have given here. The person concerned in the management of the company, the persons who are managing the company currently, they are guilty of fraud, misfeasance, persistent negligence or default. They are not a proper person. They are guilty for breach of trust. Then also the central government will start the application under this section. Then the business not conducted along according to the sound business principles or prudent commercial practices. They are not doing the business as per the proper business principles. Then the company is managed in a manner which will give serious injury to the trade industry or business. It will affect the entire industry. Then also central government can file the application. Business is conducted with an intent to defraud the creditor. The intention, the main motive to conduct the business is to make a fraud on the creditors, defraud the creditors. So then they will refer the case to the tribunal. Tribunal will inquire into the case and record a decision whether such a person is a fit and proper person. Such person who is wrong, the tribunal will decide whether he is a fit and proper person. Whether he is fit and proper to run the company or not. That will be decided by the tribunal. For this only, the central government will refer the case to the tribunal. Then the person against whom the case is filed, the person shall also be a respondent. So you are telling that this person is guilty of fraud. Then in that case, you should include this person also as a party. Then in that particular application, a concise statement of circumstances and materials. What happened? That details you should give it as a statement. It should be signed and verified that all is there. So that's all about section number 241. In these cases, application can be filed. Member can file in these particular cases, and the central government can file if they are having this doubt on the persons involved in the management of the company. Then the tribunal will decide whether he is a fit and proper person or not. The next section we are going to see is section number 244. Here we saw that section number 241, where any oppression is happening or any material change in the management or control of the company, that and all. In that case, the member can apply to the tribunal. Minimum how much members should come together to do this application? A single member cannot do the application. So here, if it is a company having share capital, then the minimum number of members is lower of 100 members or 1/10 of the total number of members, or members holding 1/10 of the issued share capital. First one, 100 members. Second one, 1/10 of the total number of members. Third one, members holding 1/10 of the issued share capital. Members holding 1/10 of the issued share capital. So these three had to take the lowest. That number, that is the minimum number of member. That much number should be allowed. Only then that much number should be gathered. Only then they can file an application. So minimum that much members should be there to file the application. Then if the company does not have any share capital, flat 1/5 of the total number of members. 1/5 of the total number of members. Then other condition what we are having, when we are counting that member, all the calls and sums due on the shares should be paid by the applicant. When you are making the application, you should have paid all the call money, all the arrear money, everything that should be paid by you. Then issued share capital, equity plus preference share capital. We are seeing the issued share capital, which includes equity plus preference. Joint holder will be considered as one member for this limit counting. So this is the thing for the minimum number of members who should gather to file an application. Then the NCLT may waive any or all of the requirements. This minimum members requirement we are having, right? The NCLT may, what we can say, waive, can forgive this requirement. Even if the number of members making the application is lower than the minimum limit, NCLT can accept the application if the matter is worthy to be discussed. Then written consent of the members you have to obtain. Then consent will be checked at the beginning of the proceedings. When you are filing the application, we will check the consent. After accepting the application by tribunal, after that some people withdraw, that and all will not be counted. Only at the time of filing the application, the majority means the limit should be accepted. Limit should be what we can say satisfied. Even after filing the application, after the acceptance of application, if some members withdraw, that is not a problem. Then legal hire of deceased member can apply even if name is not entered in the register of members. A person is there, shareholder, he dies, and now we are having a legal hire. Now, legal hire is the owner of the shares, but the name of the legal hire is not there in the register of members. Now, whether the legal hire can file the application? Yes, they can file the application even if their name is not there in the register of members. So, this is the entire thing for right to apply under section 241. Minimum how much members can apply and what are the other conditions that also we have seen here. Now the next section is section 242, powers of the tribunal. When you are making an application under section 241, then what will be the order that will be given by the tribunal? What are all the matters that can be given as an order? So that is given here. If the tribunal is of the opinion that the company affairs have been conducted in a manner prejudicial or oppressive to any member or prejudicial to public interest or company's interest, if the default is there, if the problem is there, the company's affairs are conducted wrongly, it is oppressive to any member, it is harmful to the public interest, then and when you are winding up the company, because of this reason, if the tribunal passes the winding up order, then it will cause a problem to the members or the public or such people will be affected. There is a wrongdoing in the company. Something wrong is happening in the company. Because of that reason, if you wind up the company, all the people will be unjustifiably affected. They will be unduly affected. So then we can make a attempt to regulate the company and bring the company to the right path. There is a wrong happening in the company. But if you cause the winding up of the company, if you pass the winding up order, because of this reason, many people will be affected. So we are going to do an attempt to regulate the company. What order they can pass to regulate the conduct of the company, to purchase the share by other member of the company. We will have some member who are what we can say who colluded with the directors and who worked together to do the fraud. Then we can make the other good members to purchase the shares of the bad members. Then purchase of the share by the own company due to reduction of share capital. The company itself will purchase the share, which will result in a reduction of share capital. Restriction on the transfer of share, like a lock-in period or something. Termination, setting aside or modification to any agreement between the company and the managing director, or company and any other director, or company and manager. That agreement they can terminate, do any modifications, or set aside the agreement itself. Then they can do any other agreement also. That agreement, it should be between company managing director, company manager as per this point. The next point, when you see, they can modify or set aside the agreement between company and any other person also. Other than specified here, any other person also, that agreement can be terminated by the tribunal. Then we are having company and then any other person. Between these two people, we are having the agreement, and if this agreement must be terminated, then you have to give the notice to the other person. After giving notice and after getting the consent, after that only you can terminate this agreement. Then any transfer of goods, payment, execution, property, if you made that within 3 months before the date of application. Now they are making the application 3 months before. Here you have done any transfer of property, goods, payment, everything. That and all, if it is not proper, that also can be set aside. Then removal of the managing director, manager, director, recovery of any undue gains, and manner of utilization of the recovery. So some fraud happened, and that fraud was done by the director. Now the NCLT made an order and it recovered the amount, whatever the undue gain, undue profit that was obtained by the director, they recovered it. Now this recovery, they can give it to the victim who was affected by the fraud. They can give it to the victim. So that thing is there. They can also transfer it to the investor education and protection fund. That is also there. The manner in which the managing director or manager may be appointed subsequent to the order. So currently there is one managing director. You remove the director by a tribunal order. After that, if you want to appoint a new managing director, how you can appoint, which person you can appoint, what is the eligibility test for the managing director, that also can be specified by the tribunal. Tribunal itself can appoint some person as the director, and those directors, they will report to the tribunal whether the company is working properly or not. After the tribunal order, whether they are following it properly or not, the directors will be reporting to the tribunal directly. Then any cost or any other matter can be given by the tribunal also. Then the certified copy of the order, you have to file it to the registrar. They can give any interim order also. That thing is also there. Then, as a part of the powers, the tribunal, NCLT, if it makes any alteration alteration to the MOA or AOA. Then after the order, the company cannot reverse the alteration. Company cannot reverse the alteration. They cannot do any change to the MOA AOA, like reversing the effect of the alteration made by tribunal. That they cannot do. If they want to alter the MOA AOA inconsistent with the order of the tribunal, they want to reverse the order of the tribunal, then they can do that only after getting the permission of the tribunal. Then the alteration made by the tribunal will have the same effect as if the company did the alteration normally. Then certificate copy of the order altering or giving leave to alter. So if the tribunal is altering the MOA, that order also have to file it with the registrar. Then punishment also they have given. So that's all about section number 242. We have seen all the powers of the tribunal, all the things, all the powers is there with the tribunal to set aside the agreement, to remove the managing director, to make a restriction on the transfer of shares, to purchase the shares by others, reduction of share capital, everything, all the powers are there with the tribunal under this section. They are having very wide powers here. Now we can start section number 243. So here when you see section number 243, if there is an agreement, we are having a company and then we are having a managing director, some agreement is there between them for the salary and all. Now this agreement, if it is set aside by the company tribunal, company law, NCLT, National Company Law Tribunal, if it sets aside this agreement, then this MD, he will not get any compensation for loss of office. So normally when the director is removed and they are having an agreement, they will be getting the compensation for loss of office as per their agreement. But when the tribunal is removing such person, then compensation they will not get it. No rights to any claim for damages or compensation for loss of office. Then the managing director whose agreement was set aside, the same director, you cannot appoint the same director in the same company as a director for the next 5 years. The same person cannot be appointed in the position for next 5 years in the company, in that particular company, without the leave of the tribunal. If you want to do that, you can get the permission of the tribunal and then do that. So, if they are terminating any agreement, then there will be no rights to claim for compensation for loss of office. Then you cannot appoint the same person in the same company for a period of 5 years. If you want to appoint, you have to get the permission of the tribunal. Managing director, director, manager, everyone will be covered here. I'm just saying for simplicity, managing director. Then, if the central government made an application to determine whether he is a fit and proper person or not, to determine whether a person is a fit and proper person or not, and then tribunal told that he is not a fit and proper person, then that person you cannot appoint him in any company for a period of 5 years from the date of the decision. If the tribunal says that he is not a fit and proper person in any company, you cannot appoint him for a period of 5 years. Then, if you want to appoint within 5 years, you have to get the permission of both central government and then the tribunal for the fit and proper person for that particular matter. Then, any person is removed, then he will not be given any compensation for the loss of office. But if you want to give the compensation, then you have to get the approval of the tribunal. Then tribunal also it should give an opportunity to the central government. Central government will also give the points, will give their representation. After that only the tribunal can give permission to pay the compensation for loss of office. Then penalty also they have given. When anyone is removed, they will not get the compensation. But if they get the tribunal permission, then they can get the compensation. Tribunal also, before granting the permission to give the compensation, they have to give an opportunity for the central government and reasonable opportunity of being heard. So that is the entire provision for the consequences of termination or modification of certain agreement between company and then the managing director, other director, or other person. Here we have here when you see any person they have given, like any officer, notwithstanding anything contained in any other provision of act or any other law or any contract or agreement or memorandum articles, removal of person from the office of a director or any other office connected with the management of the company. In the management, in any position they are there. Then also, if they remove it, they will not get the compensation, not just MD, director, manager. Now the next one is class action, section number 245. So here class action means a class of members or depositors, they can come together and they can file an application if they think that the company's business is conducted in a manner prejudicial to the interest of the company, member or depositor. It is not good or it is harmful to the interest of the company or members or depositor. Then the members can come together, the depositors can come together, they can file the class action suit. Now here, what is the outcome? What are all the orders that they can get from the tribunal by doing this class action suit? What are all the outcome that they can get? That is given here to restrain the company from committing an act which is ultra virus. So they are stopping the company from doing an act. That act is ultra virus, the articles or memorandum. They can stop the company to committing a breach of any provision of MOA or AOA. The company would have what we can say, violated the MOA or AOA. They stopped the company from violating it. Then, to declare a resolution altering the MOA AOA as void, as passed by suppression of material fact or misstatement. So, memorandum or article, when it is being altered, they have to get the resolution. That resolution, if it is passed by suppression of material fact or misstatement, when passing the resolution, the director misrepresented to the members. Then, in that case also, they can ask the resolution to be void. They can ask the tribunal to declare the resolution to void. Then, to stop the company and directors from acting on such resolution, the company and director should not implement such resolution. Then we can stop the company and director to do that. Then stop the company from doing an act which is contrary to the provisions of this act or any other law. Company is doing something illegal, then we can stop it. To stop the company from taking any action contrary to any resolution, the members passed a resolution. Against that, the company is working. For example, a contract is there. Whether we can do that or not, the members said that no, we cannot do the contract. But the company is implementing the contract. They are signing the contract. They are doing everything. Then you can ask the tribunal to make an to what we can say, stop the company from doing this contract. The company is acting against the resolution of the members. They can stop the company. They can claim the damages. What damages? Some fraudulent, unlawful, and wrongful act happened. For that, they can get the damages from company or director. Then the auditor made a misleading statement in the audit report. In the audit report, the auditor made a misleading or wrong statement. Because of that, some losses happened to the applicant. Then they can get the damages against the auditor. The next point is, if any expert or advisor they gave any incorrect or misleading statement, then the member, the applicant, can get the damages against the expert or advisor also. Any other remedy also they can get it from the tribunal. So this is the outcome of the order. You are making a class action suit, they can get these actions from the tribunal as an order. The next thing, if there is any damages or compensation that is asked from the audit firm or the auditor, then both the audit firm will be liable and then the partners, they will be liable for making the improper or wrong statement in a wrongful manner. The next point is minimum number of members that should be needed to apply under this section. Class action suit, if you want to do that, how much members you need? For example, if it is a company having share capital, then the member count, you can go either in two ways. Either you can go through member count or you can go through shareholding value. First one, if you are going through member count, minimum you need 100 members or 5% of total members, whichever is lower. Minimum 100 members or 5% of total number of members, whichever is lower you need. You should gather that much members to file the application. Otherwise, if you are having a 2% of issued share capital in a listed company, then you can file the application without any, what we can say, without other members also. In a listed company, shareholding, you are holding 2% of issued share capital. Then you by yourself, you can do the application. If it is an unlisted company, you should hold at least 5% of issued share capital. Then also you can apply by yourself. If it is a company not having the share capital, 1/5 of the total number of members. This is the limit for the members. Members means shareholders. The next thing when you see it is for the depositors. If you are a depositor, lower of 100 or 5%, whichever is lower. Depositor, lower of 100, 5%. Then deposit value. Here we are having only 5%. Depositor who won 5% of the total deposit. Minimum that much people they can come together and they can file the class action suit. Either you have to go through the number of members, or if you are holding this much shareholding value, you can do it. There is no problem. Now, the next thing when you see, when an application is done, tribunal, when it is considering the application, when it is processing the application to approve it or not, the tribunal will consider these factors, whether they are acting in the good faith, when they are making the application, whether they are doing it for the good cause, or they are having any other wrong intention, that they have to see. Then, if any person other than director or officer, other than the director, other than the officer of the company, any other person, if he is involved in this matter or not, that should be examined by the tribunal. Then any evidence before it as to the views of the members or depositors who have no personal interest. Now, there will be other members or other depositors also who are not filing the case, who are not involved in the matter. What are their views? What is their view? Whether they also think that the company is managed in a wrongful manner or they think that the company is okay, that also they have to consider. Then, where the cause is an act or omission that is yet to occur, whether it is likely to be authorized or ratified by the company. If the action did not occur till now, it is going to happen. Now only they are filing the application to stop the future action. Now they can say whether it will be authorized by the company, whether the company can authorize it before it occurs or the company can ratify it after it occurs. Before it occurs, the company can give the approval, or after it occurs, the company can ratify it. Not also give the approval only, but after the completion of the act. If it can be done, if it can be approved and regularized by the company approval, then there is no problem. That also they will consider. Then, if the action already occurred, whether the company can ratify the action, they can give the approval after the completion of the act, whether that is possible, that also will be viewed by the tribunal. Then, whether the cause of action is such one which the member or depositor could pursue in his own right rather than through an order. The what we can say, the outcome which they want, whether the member or depositor can they do it by themselves or an order is needed by tribunal. The outcome whether they can achieve it by themselves also or an order of a tribunal is required to achieve that particular outcome. That also they will consider. So these are all the things that will be considered by the tribunal when they are making an application under this class action suit. When an application is submitted, what will happen? For all the members, all the depositors, a public notice will be served. Then, similar application for the same particular matter, if it is there in some other jurisdiction, some other place it is filed, then everything will be combined and they will have the right to appoint a lead applicant. One applicant, he will lead and he will do the case. Now, not all the people should be involved. One applicant will take forward the case and handle the case from now on. The shareholders or depositors who made the application, they can select the lead applicant. If they are not able to select, then the tribunal itself will appoint a lead applicant who will be in charge of the proceedings from the applicant side. Then, two class action application for the same matter cannot be there. It is not allowed. Then, the cost or expenses will be compensated by the company. The legal cost will be paid by the company or the person who did the oppressive act. The order of the tribunal will be binding on all the expert, audit firm, depositor, member, everyone. Punishment for non-compliance. Then, if the application was made for a frivolous purpose, like it is a useless application, just they came to waste the time of the tribunal, then they will impose the cost up to 1 lakh rupees. Banking company, for a banking company, nothing will be applicable in this section. Then the next point is, it is not necessary that just the person affected should come forward and do the class action. Any other person who can file the application, they can also file it on behalf of the person affected. The person is affected, on behalf of that another person, they can file the application. Not necessary that the same person should come and file the application. So that point they have given here. Then here they have given section 241 or 245. When you are making an application here, 241 normal application, 245 class action suit. If such an application is made, then this section also will be applicable here. Penalty for fraud, liability where proper accounts are not maintained, for fraudulent conduct of business, power of tribunal to assess damage against the delinquent director who are not following the directions of the tribunal. Then liability to extend to partners or directors in firms or companies. Then this section also will be applicable in case of this particular application under 241 or 245. Now we have completed the chapter of prevention of oppression and mismanagement. We have covered all the sections, but when you see this kind of example boxes, I did not cover. This is very easy only. If you read it, you will easily understand it. So there is nothing to explain here. So I am not covering it. You can read it once by yourself. This you have to read it. From this also they can ask the question. Some case laws, everything is given here, but they are simple only. So you can read it by yourself. Otherwise, we have covered all the sections in this particular chapter.